All right, good afternoon. We're going to give it just about 30 more seconds, then we're going to get started. I've got 6 o'clock Eastern Standard Time, 3 o'clock Pacific. So we're going to get started in just about 30 seconds here. We got a lot of people still logging on. Just want to thank everybody for being on today. I know this is some interesting times in the federal government as we approach these webinars. We're in the middle of a shutdown. There's a lot of moving parts here. So what we want to do is really just try to keep things simple today. And estate planning is never a simple topic, but we're going to try to make it easy as we go through here. So here's a couple things I'm going to tell you up front is as we go through this information today, be very clear. This is going to be very general information on estate planning. I'm going to give you some ins and outs, some things to think about, some nuances as it pertains to the federal government. But, every single state has their own estate planning rules and laws, and there's a lot that goes into it. So take today, there's going to be general information, understand what your state entails, and at the very end of this workshop, here's what's going to happen. We're going to give you the ability to ask all the questions you want. Obviously, we can't do it live right now because we have so many people on, thousands of people across the country on this. We would never be able to do a Q&A. But what I want to do is at the very end of this workshop, you are going to have the opportunity to get your questions answered. So you'll be able to fill out a form at the end. What I always recommend doing is write a book to us. Like, let us know how we can help, because you will get every single one of your questions answered as part of being on here. We did this workshop earlier. We had almost 1,000 people on, and we had some incredible questions from a lot of your fellow coworkers in the federal government. So we get a lot of estate planning questions. It's a big topic of conversation more than ever. There are so many rules changing all the time around estate planning, and I'm going to give you the rundown today on some of these rules as we go through here. But for those of you that have not attended a MyFed University webinar or seminar before, welcome. If you've attended one in the past, welcome back. My name is Ryan Palomini. I'm a network representative of MyFed University. I've had the privilege now of teaching these workshops for over a decade all across the country. We're based here out of Raleigh, North Carolina. I own a registered tax and wealth management firm that really specializes in estate planning and tax planning for federal employees. And that's what we're going to really hit on today is some of the ins and outs, some of the common mistakes I see federal employees, not just federal employees, but just people make when it comes to estate planning as we go. So real quick, before I dive into everything, I want to give a couple disclosures. Once again, network representative of MyFit University. I'm trained to conduct these educational workshops all around the country. You're going to hear me talk a lot about estate planning and tax planning. Be very clear, I'm not an estate planning attorney. So today is general information. So what I don't want you to do is take what I say and go take it as advice, because I don't know your situation. We have an entire platform, an entire estate planning concierge platform that you can get your estate planning done, you can get estate planning questions, and so answered. So we will be able to make sure you get what you're looking for as long as you ask us for it. So at the very end, you can fill out a form and put your questions down. Like I said, had hundreds of people from the earlier webinar had asked some really great questions that they're going to get their questions answered, and you can too. All right, so here's a stat. I want to start with this because this is overwhelming when I look at this, and it really just kind of puts us into perspective. Okay, so according to trustandwills.com, only 55% of Americans do not have a will or trust. 55% of Americans do not have a will or trust. That means that more than half of you on this call do not have a simple will. You do not have a trust. You don't have any powers of attorney. There is statistically says that half of you on here have not even started this process. Okay, and I'm going to explain to you all the intricacies of why it needs to happen. But so only 31% of Americans have a simple will, and just 11% have a trust. Those are astounding numbers because it really tells me that we have a long way to go. And it's really more of the importance than ever to have your affairs in order. And that's the biggest thing, is as you make these kind of decisions, it impacts your family in so many different ways. And when I look at this and I go, only 55% of America, or really 55% don't have a will or trust, That's a problem. And so I'm going to give you some information today as we go through to kind of help you understand a little bit of how this can help your family and why you need to have it done. That's so important. Now, here's just a quick overview of the agenda. We're going to talk about estate planning, the essential documents, revocable living trust, estate taxes, and probate. I'm going to give you a couple stories around probate, which again, if I went around and asked every single one of you, hey, give me a story, a scary story, right, about somebody you heard go through probate, you could probably give me that horror story of, oh man, I had a family member that passed away and it was tied up in probate for 2 years because they couldn't agree on X, Y, and Z. The sad part is most of the time that can all be avoided if your affairs are in order the correct way. Okay, a lot of people have a plan, they have an incomplete plan. So we want to try to fill in some of the voids as we go there to help you avoid probate as much as possible. And then we're going to talk about your estate plan, and we're going to summarize everything up, and I'm going to give you some action steps on what you can do to begin this process. Now, when you think of an estate, here's the problem. A lot of people think of an estate as a will and a trust. An estate is so much more than just your wills and your trusts, okay? An estate, if you look up the word estate, it is a total sum of your entire assets, okay? So people think, and once I've got a will and I got a trust, I'm good. No, there's all these other things that go into it. What about tax planning around your estate? Is your estate being distributed in the most tax efficient way? Do you understand what in the estate is going to be taxable, what's not? Even though we have this huge exemption now, still doesn't mean that you're going to pass things tax free. How about your income plan? How does your income plan affect your estate plan? What about life insurance? What about if you passed away today, do you have a burial plan? Do you have enough to cover your burial expenses? Do you have a term life insurance to cover your debts? Because guess what happens? When you pass away, who gets paid first? The creditors. They get there first. They are the first to be paid, not your family, your creditors. So do you have enough in asset to cover the creditors and still leave money behind? I see it all the time. People have an outstanding mortgage, 200,000-300,000. They want to leave their house to their kids, but that's all they have. And it's like, well, what about putting an insurance policy to pay for that so your kids don't have to, right? And get tax-free death benefit. Life insurance can be used in so many ways for estate planning. Some of the most wealthy people in this country, they use incredible amounts of life insurance to cover tax burdens. Why? Because life insurance death benefit is tax-free. Okay, so again, there's so many ways to this, but I want you to take estate planning and not just think about it as a will and a trust. I want you to really think about it as a holistic approach to your financial life, to your entire estate. Okay, now again, this is taxes, this is asset transfers, this is wills and trusts, this is funeral, this is who your trustees and executors and all these things. This is long-term care, right? That a lot of people don't even have, that really, really is needed now more than ever because we're living longer than ever, right? And so part of the reason why people's, their families run out of money when they pass away, or not even when they pass away, while they're still alive, is because they spend so much money on the cost of long-term care. There are so many ways now to be able to fund and utilize long-term care much differently than it's ever been. Let me give you an example. A lot of you in the federal system, you don't even have access to your long-term care anymore, the standalone one through John Hancock's. They were going to put it back in, they didn't, and they did, and they didn't. It's a mess, and a lot of people don't do standalone long-term cares because the cost is very expensive. There are ways, and I'm going to give you just a quick tip here, because again, from a tax planning perspective, why this is so important to your state. There are ways in the IRS code that you can use things like your TSP, qualified pre-taxed accounts, to be able to fund long-term care policies and get tax benefits for doing it, get tax breaks for doing it. Most people don't even know that. So many people are so afraid to, go out and get a long-term care policy because they think they're going to have to pay thousands of dollars every month out of pocket, when in reality, you can use assets to be able to fund long-term care. And what does that do? That really helps protect your estate, because now you don't have to worry about your estate being drained down before you even pass away, right? So there's so many things that you can do to be able to help your estate. And that's why I wanted to make sure I make this clear today, that your estate is so much more than a will and a trust. It is your entire holistic approach to your financial life. And a lot of people don't look at it that way. So I want to start here. And by the way, like I said, any questions you have on anything that I'm talking about, feel free to write them down and we'll get your questions answered. That was a big one. A lot of people asked about the long-term care piece because it's a big topic of conversation amongst federal employees today because it's hard to get, but there are so many ways to fund it. And it's a really good piece to your estate planning puzzles. You kind of look at all these bubbles, right? You can see so many moving parts, and it's your job to make sure all of these parts are checked off. And that's a big component to all this, and having everything work in harmony with each other, right? So again, we're going to dive deeper in all these things, but I wanted just to start with making sure that we're understanding it goes so much far further beyond just the will and trust. Now, let's talk about some of the essential documents. So there's two powers of attorneys that everybody needs to have. And this is a very important piece that a lot of people don't understand the power of. And I'm going to give you a couple examples, but there's financial power of attorney, and then there's durable power of attorney. And that covers pretty much everything else outside of finance, like your health care and so on and so forth. But your financial power of attorney is when you make a selection to the person that if you are unable to make financial decisions, maybe you are, and it's not even so much when you pass away, right? It's while you're still alive. Maybe you go into a nursing home because you have dementia. Maybe you're in a car accident, you're in a coma. Who's going to make financial decisions? Because unfortunately, the creditors, they don't care what your life situation is. I'm not trying to be mean, but like they don't care. And so your mortgage still needs to get paid, even if you're in a coma. They don't care about that. You know, I mean, if you have dementia, they still want to get paid. So someone has to be in charge of making those financial decisions, somebody that you trust to be able to make those financial decisions on your behalf. Okay, and the same thing with healthcare. This is so important because healthcare is, you know, if you're in the hospital and you need urgent care, who's going to make those decisions for you? Who's going to make that final decision? My goodness, if you ever have to get to there to pull in the plug, who's going to make that decision? Or, you know, who's going to help administer and make sure they're watching over you, making you're getting your medicine properly, and all these things that go into healthcare, which is harder than ever because so many moving parts now. But who's going to be responsible for your healthcare and your finance? That is a person that you need to assign as a power of attorney when you are in a position to not be able to make those decisions. Now, a lot of time, if you're married, it could be a spouse. If you're not married, it could be a family member that you trust. But again, these are important pieces to your retirement puzzle, but also to your estate planning puzzle as well. Okay. Now, let's talk about a couple of the pieces to this. So a will. Now, a lot of people have heard of a will. I've even heard it referred to as a, as a napkin plan, right? Where you can write down, these are my wishes. And there are times where the court system would look at that and say, hey, you wrote your wishes down on a napkin, you signed it, and that's your will. I would never, rely on that, to be honest with you, but I've heard that a lot. But I got to tell you, after 10 years or more than a decade of doing estate planning and tax planning, this is obviously a very important piece to your estate planning. It is not, just to be clear, this is the beginning to estate planning. This is not estate planning. If you come to my office, you say, no, I got my estate conversation about what an estate plan actually is, because this is a simple document that has a lot of abilities to have holes poked in it in a lot of different ways. So this is when you are going to be the executor. You're going to assign who your assets are going to go to, how you want them to go, and unfortunately, you can't just say, hey, I want my kids to get at this, this, and this. That's not what the will is for. The will is to outline the distribution and say, I want my son's going to get this, my daughter's going to get this percent, and that's what it is. And it's also a very important document for you that have minor children to name the benefit, to name basically your guardian, someone who's going to be able, if you pass away, who's going to take control of your minor child and then make all those decisions as well. See, that's where the limitations come in, because you can't, in a will, for the most part, start spelling out, hey, I want you to be able to take this money and give this much to my kid at this moment, and this much. That's not what a will is for. That's when you start getting into trust territory, right? Think about a will are your wishes. A trust is when you are controlling your finances from the grave. I know it's really weird to hear and say, but that's really what it is. Your wills are your wishes. I wish to have this happen. I want to have this. I want my kid to get this. This is the legal guardian that I chose. And that's where it goes. And I want to hit on this legal guardian for a second. We had a situation, and I'll give you one of my client situations. So we had a client come in and they wanted to get their estate planning done because all they had was a simple will. And they came in nervous because a friend of theirs had their will done, had named the legal guardian, and they passed away. And so now, if you just have a simple will, what's going to happen is everything is going to go to probate court. Okay, there's no way around that. Everything is going to go to probate. And when that happens, okay, when you go to probate, the court starts deciding things for you in a different way. Let me give you an example. If you have a legal guardian for your minor child, and the court system deems that legal guardian as somebody who is not fit to look over a minor child, they will then decide the next person. And that was a situation. This person that they had assigned as their guardian for their minor children, well, that person had something on their record that the court system didn't like and didn't deem them fit. See, these are problems. These are things that you really got to think about. So as you start building out your estate plan, the people that you choose and having secondaries are equally as important as a primary, right? Because this is what happens. This goes to court. And by the way, here's the thing about a will that's also really difficult. It is incredibly contestable. What does that mean? That means that you can make all the decisions you want. You can say, I want my son to get this, my daughter to get this, my wife to get this, or my husband, or whatever, however you decide it. But then all of a sudden, a couple things happen. When you just have a simple will, your entire estate becomes public knowledge, by the way. So that means that if you pass away and your estate goes to probate, which it will, everything that you have asset-wise is going to become public knowledge. And what does that lead to? Well, that leads to people, random people, family members most of the time, right? Let's be real. Some of the problem childs, not just kids, but just problem family members in general, right? They come out of the woodworks and all of a sudden, they think they're entitled to part of your estate because they realize, hey, wait a minute. I didn't realize that Aunt Sally had, $1.2 million in total assets. I think I'm entitled because I spent every summer with Aunt Sally and, and my cousins growing up. So I think I'm entitled to something. And then what happens? That person goes to the court and says, wait a minute, I think I'm entitled to a portion of this. And then what happens? Then you have to now hire another attorney, and you're going to have to go through the entire process of your family's going to go through that process, not you, you're not here, but your family's going to have to go through that entire process of fighting that in court. They're going to spend more time, they're going to spend more money. And I will tell you, when a will gets contested, which are very, very easy to do, when a will gets contested, the average turnaround time before assets get passed out is 2 years. It is incredible to think about. And I'm going to tell you, it happens all the time. So while a will is great, it is the beginning part of an estate plan. Remember when I showed you that big bubble? So many people think, hey, I've got a will, my estate plan is done. Oh, that has nothing to do with tax planning, has nothing to do with income planning, insurance planning, so on and so forth. We can go down the list of all the things that's not an estate plan. That is the beginning part of where this is where you start. Now, some of the benefits of a will is, like we talked about, establishing legal guardianship, determine how you want these assets to be distributed upon death. You can say, hey, I want my daughter to get 40%. I want this to get 20%. I want this. And those are things you can list in a will. You can even put some specific bequest, which is where you say, hey, I want them to get this ring, or I want them to get my car if I die, and I want this. That's part of this. There's when you start getting into the trust, you can get a little bit deeper into those decision making processes, but a will can handle some of how those things are determined. But here's what's not going to happen in just a simple will. Okay, the average inheritance is gone in 18 months. 18 months, the average inheritance. So I want you to think about this scenario. And again, if you don't have children, think about just somebody in your life that's going to inherit your money. You may be single with no kids, no problem. Same situation, right? If you pass away and all you have is a will, and it says, when I die, my son, my daughter, whoever it's going to be, they are going to inherit my TSP, and I've got 600 grand in my TSP, and they are going to inherit because they're beneficiaries. Wonderful. However, if they inherit that day, which I'm going to give you the ins and outs of TSP in a second, if they inherit it that day, what do you think is going to happen to taxes, number one? And what do you think a 25-year-old child is going to do with 600 grand? You wonder why the average inheritance is going in 18 months. Can you imagine a child, I say child, a young adult, right, who's somebody in their early 20s, early 30s, maybe is not yet at that maturity level to handle that type of influx of cash, number one. Can you imagine the things that would get spent on? And that's why when you start stepping it up a little bit to having a trust is when you are going to start having much, much more control of your assets from the grave. So this is a situation where you pass away, you can fund the trust, and the money goes into the trust first, and then you can say, you know what, I want my children to receive my assets, but I don't want them to receive it all at once. I want them to get 33% when they're 25, 33% when they're 30, and I want them to get the final distribution when they turn 35. But in the meantime, if they get married, if they can start a business, if they go to school and they need extra, those will be some of the stipulations that would trigger them to have the ability to get access to a little bit more cash, because that's an agreed upon part. You see, that's not in a will. That's a trust. And that's why it's so important to understand the different levels of estate planning, especially as your assets grow. These things become more and more important. Okay. Now, then you have now there are two different types of trust. There is a irrevocable living trust, which is where basically once it's set, it is set in stone. Now, there are ways to be able to tap into it and make some changes. However, that comes with a lot of limitations. Okay, so an irrevocable living trust is used more to protect from Medicaid spend downs, and I'm not going to get into that. That is way too complicated for today's conversation. But the irrevocable trusts are used more to protect from Medicaid spend downs and nursing homes, all that kind of stuff. Most common is the revocable living trust. That is when you can make changes as long as you're alive, and most of the time it covers a spouse. So if you're married, a revocable living trust will cover you and your spouse, right? So kind of all in one. And then you can make choices in there. You can say, hey, I will allow my spouse to make changes without my consent, or no, if any changes are going to be made, there has to be written consent from me and my spouse that things are going to be changed. That's where a revocable living trust starts coming in, because then you can be the trustee. You can assign a successor trustee that's going to take over, and that's going to be the person that's in charge of running your estate in the event of you passing away. And again, it's also about how you distribute your assets here. That is the really important part to this, okay? It's how you control your assets from the grave. Now, I'm gonna give you something maybe a little bit more advanced, but I'm finding more and more as pertains to a lot of you on the call, so hear me out on this. There are different levels to estate planning. Some of you have rental properties, and I run into that a lot. Maybe you have rental properties. Maybe some of you have a side business that you have, or maybe you're a federal employee, but your spouse is a business owner, right? That starts getting beyond the basics of estate planning. Now you're getting a situation where you need to have this thing called an operations agreement. And again, it's a little bit more advanced, but this pertains to a lot of you lately that I've been running into, so I want to hit it. So think about this. If you have a rental property, one of the first things that should be done is that rental property should go into an LLC. Now, my guy, I can't tell you how many people fight me on that. A limited liability corporation is something that protects you. It limits your liability individually. So you need to have that in place if you're going to run a business, or you're going to have rental property and rental income. But once that happens, the next thing you have to do is have a separate document that's called an operations agreement. And the operations agreement goes as part of your estate. But if you have a business, or maybe your spouse is a business owner, or you have those rental properties, the operations agreement is part of your estate that tells your family how to continue to run your businesses, or your business or your rental properties. If you pass away, you could say, hey, it's going to go here, sell it this way. This is what we think the value is. I want you to continue to keep running it this way, put this person in charge. Like, that's, you can get deep into operations agreement, but that's something that's important for estate planning. And again, that's where I'm going to end on that, because I know that's just a little more complicated, but I get that question a lot and I wanted to address it because I do see it as we go through this. You think about all these things that go into a revocable living trust. You have the legal process, grantors, beneficiaries, trustee, properties. The beneficiaries, I mean, everything, all the laws, all the persons, all the incomes, all the timing, all the planning. These are all things that go into just a trust that plays an important role. So, what are the roles, and how are these kind of separated? So, you are the grantor. So, the grantor is simply the person that puts the trust in place, right? So if you're the one that owns the trust, you're the grantor, you create it, you decide what goes in, you decide who the beneficiaries will be, you decide how you want these things to be distributed, so on and so forth. Now, on the flip side of this, you have the trustee. Now, this is a person or a company, depends on your situation. Most of the time it's a person. Then they're going to be the person that's going to manage the trust. Now, the thing is this doesn't always have to be a beneficiary. This could be a third party or a person of value to you that is responsible enough to be able to handle this. So if you pass away, and maybe you have, again, kids in their early 20s or whatever, just a family member that's really trustworthy, this is the person that is going to manage the trust. They are going to be basically like the owner at this point of who's going to do what, right? So think about a business, somebody who's managing a business. The manager steps in and they make sure everything is running smoothly. This person got this distribution. The lawyer got paid this, right? All of your debts got paid. And so that person's going to be responsible for making sure the distribution goes smoothly after you're gone. Okay. And now the beneficiary is a person or a company who's going to receive benefits from this living trust. And so choose them wisely. And here's the thing is, we all have people in our lives that we don't want to inherit anything, right? I mean, there's always kind of maybe that one family member that could be a problem. And that we talked about contesting, your will, or contesting, that think that they're entitled to something. But as you start building that wall around your assets with a revocable living trust, you are now putting up barriers to entry, what makes it really difficult for people to be able to tap into your trust and get through it. But here's the thing, you can take that a step further, and you could actually put in to basically disempower somebody from being able to go in there, right? You can distrust them. And what that means is, as you go in, you can say, hey, I know that if I pass away, this person may be next in kin, but I do not want them. I want to disinherit this person. I don't want them to be part of my estate, and that's legally drawn out. And if you do not have that legally drawn out, and let's say that the successor that you chose also passed away, and then the person that you don't really talk to a whole lot is now the next in kin, and they are the ones that are going to be granted by the court to make these decisions. You don't trust that person, right? You can disinherit that person and not allow them to be even in the line of next in kin to make those decisions. See, I want to stop for a second because I know I'm throwing a lot at you, but I want you to start understanding the power of having your affairs in order. It is not just about, well, if I died, no big deal, everything's on the beneficiary. Yeah, got it. That's about 50% of this, right? Everything else becomes so much more important and so much more valuable as you start putting all the pieces together. That one beneficiary piece only plays a small role here. Let me give you an example. As while we're on the subject of beneficiaries, I'm going to give you a couple pieces of tax planning that is so important to estate planning, because they go hand in hand, by the way. And what always bothers me, and I want you to think about this, if you've gotten your estate plan done, when was the last time it was reviewed or renewed? Because I did a workshop last week in Virginia Beach, and I had someone come up to me, we were talking about estate plan, like, yeah, I had my estate plan done 26 years ago. Holy moly. All right, let me ask you a question. Has anything in your life in the last 26 years changed, right? Have you gotten married? Have you had children? Have you gotten divorced? Has someone died that was a beneficiary? We can go on. There's somebody now you're no longer talking to that used to be, a beneficiary or successor or trustee. I mean, think about all the things in your life. You want to make sure that you're getting your estate plan renewed or at least updated every 3 years minimally, because so many things happen in life. Look what happened in the last 2 weeks. Some of you are trying to figure out if you're going to go back to work after the government shutdown, right? I mean, that's just, you're going to make decisions that are going to change day to day, year to year. So make sure that you're up to speed on all those things. Now, from a tax planning perspective, okay, this is really important. And I'm going to go over what the new laws are around the taxes and the, how much your estate could be worth for you have to worry about taxes. But there are two really important pieces that are going to play a role here. Number one, when the new Secure Act came down, they changed estate planning in a very drastic way. Here's an example of what I mean. They used to have this thing called the stretch IRA. The stretch IRA said, anybody other than a spouse, so take your spouse out of the equation for a second. If you're not married, this could be your kids, it could be family members. Anybody other than a spouse used to have basically a lifetime to take distributions from your traditional IRAs, TSPs, 401ks, anything that is pre-tax, so traditional, they would be able to stretch it out. Well, that went away in 2020. And now we have you own your children or anybody other than a spouse, they only have 10 years now to draw down all of your assets that are pre-tax and pay the taxes on them. As a beneficiary, that's important for you to understand that when you're signing beneficiaries. Your child, maybe think about this situation. Maybe your child is 35 years old and they're in their prime working career, right? They're starting to finally make some good money, maybe 75, 100 grand. And all of a sudden you pass away, they're the beneficiary. And now they have 10 years to draw down that $500,000 that you worked so hard to save. Well, think about what that's going to do to their tax bracket. Some of you may go, who cares? It's free money for them. They do, but that could really mess them up, because if they're making 100 grand, they have to take $50,000 a year. Well, that's good. They're going to get that money, but that could be the difference between them going from a 12 to a 22% tax bracket. That changes the dynamic a little bit, right? So passing assets tax efficiently is just as equally important when you're looking at estate planning. And that's why I said, think about estate planning, take the word planning out, just keep the word estate. Estate is all of your assets encompassing, right? So anything that's a traditional, pre-tax, they now have 10 years to pay it down. On the other flip side of that, anything that is a Roth is going to get passed to them tax-free. That's why we do an incredible amount of things like Roth conversions, because Roth conversions, while you're alive, allows you to begin the conversion process and you pass away, that money gets passed to your family tax-free. Now, I'm going to take TSP a step further. Now, this is not a bash against TSP. I think TSP is a phenomenal tool during your accumulation phase of your life while you're working. Where the shortfalls begin is the distribution, the tax planning, and the estate planning part of your life, okay? So hear me out on this. That 10-year rule applies to anything basically in the private sector. So for example, if you moved your TSP to an outside IRA, if that's your choice, now you fall into the 10-year rule. So if you die, your family's got 10 years to draw that down, everything I just went over. TSP, however, plays by their own rules. Most of you do not know this, I can guarantee it, and this could be a vital mistake to your estate plan, okay? TSP has a rule where if you pass away, or when you pass away, your beneficiaries, if they do not move the money out of TSP in 90 days, there is no 10-year rule on that. They get a check for 500, or let's say you have 500 grand. If they don't move the money in 90 days, they are passing that entirety to your family, to your kids, to whoever, and they have to pay the taxes up front. There's no 10-year stretch on that. That's TSP that plays by their own rules. So now, think about this. If you had that, if you didn't know that, and your child now inherits $500,000 that day, they just lost a third of your retirement that day to taxes. And you put them in the highest tax bracket humanly possible. They probably lost 50% depending on the state you live in. Okay, that's a huge piece. Now, had that gone through the trust, you have more control over that. But again, I'm not, you got to choose what's right for your family. I need you to understand two things. Understand the laws of your state, understand the rules of TSP, because they have some weird ones because they basically create their own. It's one of the only companies I've ever seen that has the ability to create their own rules out of thin air. They don't follow the IRS guidelines most of the time. Okay, and that's really important to understand and know. All right, now, so I want to hit on that. That's important. I'm going to give you one more tax piece here. If you have a separate brokerage account, some of you probably have maybe a Schwab or an E-Trade or whatever account, and you started a Robinhood nowadays, and you started from with cash, and you've grown it and you've grown it. See, that's called non-qualified money. That is, those things are subject to capital gains tax. But here's why I don't mind those as passing assets to families, because here's what happens. When you have a brokerage account, you've already paid the tax on it's going in, so now your capital gains. When you pass away, your family that's going to be the beneficiaries of that or inherit that are going to be subject to what's called the step up in cost basis. What that means is that if you started with $100, right, and you've been putting money in, you're growing this account, and now all of a sudden that account has grown to $300,000 because you've been putting money into it in his brokerage account, and you die. What happens is the IRS basically takes a snapshot of that account the day you died. And then from that moment forward, any more growth that's in that account, your children are now responsible for the capital gains on that. The first 300,000 that grew to, they are not responsible for the capital gains tax. That's called a step up in cost basis. Okay, so again, we came in as maybe thinking we're talking about wills, some trust. There are so many pieces to this, and like I said before, every single part of your estate has got to work in harmony with each other, or there's going to be a lot of mistakes made. Okay, now here's some of the benefits of a living trust. It avoids probate. Not all the time, most of the time. Okay, everything goes to probate, but the whole process, this whole extended process, and if you just have a simple will, by the way, you're looking at anywhere from 8 months to a year to settle the estate. Okay, and I want you to think about this too. Most of you, if you're going to avoid probate, most of you don't even know this. Every state is different. If I came to you and I said, what do you think is considered a large estate? So I live in North Carolina, and I had to go through the probate process earlier this year with a family. And we found out that in the state of North Carolina, for example, what do you think, if I asked you, what do you think a large estate would be? What do you think it would be? Just think about it for a second. A couple 100,000, a couple million. What is a large estate? In the state of North Carolina, a large estate is considered anything over $20,000. That is a large estate. And guess what happens? When you hit that 20,000, you just triggered the entire probate process. Now, what's the largest state in your state that you live in? And how are you going to avoid that process? Here's the other thing I need you to know. For those of you that have kids, and I'm going to give this to you at an unfortunate experience, okay? I lost a child, and when you lose a child, or if you have a child that passes away, and you have, maybe let's say you set up a college account for them, an UTMA, a 529, a brokerage account for them, whatever you set up for them, and they're the owner of the account, but you are obviously the guardian. Did you know that if they have an account that is in their name tied to their social security number, even though you are the legal guardian of that child, they are technically the owner of the account. If your child under age of 18 does not have a will that determines that you are the beneficiary of that, because again, not all accounts have regular beneficiaries, UTMAs, some of these accounts don't have beneficiaries. If they don't have you as the beneficiary, then they don't have a will, probate is triggered. And it's amazing to think about these things, okay? And even things like your powers of attorney. When your child turns 18, you need to make sure that they have a power of attorney in place, because that's the part where they are adults and someone has to make those decisions for them. So the benefits of a living trust is helps avoid probate, saves time and a lot of money. Again, generally considered more difficult to attack. So that is that thing where it's really difficult for contestability. So for someone to say, I think I'm entitled to, the judge is going to look at this and go, your name's not even in the trust, right? No thanks. And by the way, it also keeps your privacy in order. Remember I told you, if you have just a will as public knowledge, a trust keeps it private. You don't want everybody knowing what you have. Why would you, right? So again, that's part of the process of probate. And there's so many different here's all the questions, right? What's a letter of administration? Who gets what? What's probate court? What's contesting? What's petition to discover assets? I mean, on and on and on. Inheritance, disinheritance, all these things are part of the probate process. Now, with the new big beautiful bill that just came, the tax update's gone through the roof. The single tax exclusion amounts $15 million for a single person, or $30 million for a married couple. Most of you, right, are not going to have an issue where the majority of your estate is taxable. That is not true for what we just talked about, right? Anything that's a traditional IRA or a brokerage account, those things are going to be taxable depending on how they get passed. Anything Roth, tax-free. Anything life insurance, death benefit, tax-free, right? There are ways to be able to pass these things on to your kids tax-free to make it easier on them. Now, what's the probate process look like? Okay, this is a legal process where your assets are formally passed to beneficiaries. It is time-consuming. It is expensive. You are going to have to hire an attorney for this. There's no way around it. I mean, unless you know the ins and outs of the probate estate laws in your state, you're going to have to hire somebody that understands this process. Minimally, it's going to be about $4,000 to $5,000 to hire an attorney to go through this process. I mean, on average, it's about $4,000 around the country. So there's a cost that comes with this. There's going to be a delay in disbursements to your state, and it could be completely avoidable. Now, I know the word completely is a little bit out there. Most of the time, if your affairs are in order, it can be completely avoidable as long as you have things in proper order. Okay, and that's important. Now, a living trust is a vehicle that allows you to quickly and easily transfer property, and not just, I'm not talking about physical property. It could be your assets through the trust. Think about the trust as like a holdings entity, and that holdings entity is going to hold all your assets and then distribute them the way you want them to be distributed, at the time you want them distributed, when you want them to be distributed, to whom you want them to be distributed to, okay? And that process can take place much, much faster when the trust is in place versus that will that's going to be contested. The court's going to take their time going through there. Like there's a lot that goes into that, okay? So your estate plan, let's talk about this. These are the most important pieces to your estate planning, is your financial power of attorney, your healthcare power of attorney. Like I just said, anybody over the age of 18 needs to have these powers of attorneys as well, because the day your son, your daughter turns 18, yes, you may be their legal guardian. However, now that person's an adult, and there may be someone that disagrees with you, the parent's decision on a healthcare or keeping them on life support or whatever the situation may be. And you need to make sure that if you have a child, and even if they just turned 18, make sure you put their powers of attorney in place so that they can be taken care of, okay? Your last will and testament, again, anyone with a minor child definitely needs to have a last will and testament, because make sure that the legal guardian is put in place. Revocable living trust, again, people who own real estate, you'll benefit from having that. You know, your personal property. I see here's what happens all the time is, you know, you may have all beneficiaries. You can say, I don't want to put anything else in a trust, just I want to make sure my house is transferred the right way. And in some states you can do a transfer on death, but you know, so on and so forth. But one of the most common things we see is when a home, you change the deed of your property into the name of the trust. So if you create the Smith family trust, and then you put your home in the name of that, and now you change the deed right into the name of the trust versus you personally. Well, now you pass away, your home can go through the trust. And again, I'm not giving legal advice here. That don't take anything I'm saying as legal. Every situation is different depending on the state you live in. You have to understand the laws in your state. I'm just giving you common things that we see often. Okay. Now, again, essential language for estate planning. I'm not going to go too deep into this, but you know, who's going to withhold distributions and how that's going to happen. Medicaid versus Medicare. My goodness, again, if you don't have it set up the proper way, you know, your family could lose a lot by having it go through a Medicaid spend down if you don't have all these things in order. You know, who's going to be sprinkling out the provisions for the minor beneficiaries? How do you avoid minimum distribution penalties on qualified assets if this is not in place? I mean, you know, you can set it to where I want my trust to, you know, make sure that the taxes are being withheld on distributions, so on. I mean, there's so many things, there's so much language that goes into a trust that can really help your family as you pass these assets on. All right, so here's a quick summary. All right, this is your estate plan. So everyone has an estate plan. It's either you choose it or the state is going to do it for you. Let me be very clear. You have a plan. Even if you didn't do it, the state one has one for you. It's going to be their decision. It's going to be their decision on who the beneficiaries are going to be, who should get what, who's the legal guardian for your children, you know, who's going to get your home when you pass away, how are the creditors going to be paid first, and so on and so forth. You have a plan. It's either you choose it or someone's going to do it for you. Okay. And when you're developing this plan, I know this is so difficult to think about, but plan as if you're going to die today. If I were to pass away today, who do I want to get what? And these are big decisions, by the way. These are not easy decisions. We're here to help. Like I said, at the very end of this workshop, I know I probably generated a lot of questions for you. Probably came in with a lot of questions. I probably generate even more. I want you to write all these things down, and I want you to put them into the survey that pops up, so we know how to help answer your questions. You're going to have the opportunity for a one-on-one and get these questions answered, but I want to know I can help you. But these are things that are important, and these are things that you have to think about. And we've helped a lot of people kind of maybe narrow it down too, right? To people who, maybe I was thinking about this person, but let's think about it this way. But think about if you were going to pass away today, how do you want these things to be distributed? And again, it is not like getting my estate plan is not an event. All right, got it done. That's done. Stick it in the safe and never look at it again. It is a process. It is something that changes regularly, something that needs to be looked at regularly, updated regularly, because life happens and things change all the time. And that's going to be really important as you go and you start building this out, okay? So again, understand and be open to the process. And again, remember the national cost to something like this. And why do people put off their estate plan? Well, because of cost, right? So there's a few things you can do. You could do nothing, put it off. Some of you have done that, and I'm just kind of saying, like, let's get moving. Today's the day. I don't care where you do it, how you do it, just get it done. You procrastinated long. I'm talking to some of you, the procrastinators. You procrastinated long enough. I'm going to get to it. Yeah, I know I need to do it. You know, I should have done it 10 years ago when my child was born. I don't have it in place. For 49 minutes, we've gone over all the problems that you could run into if you have nothing. So don't put it off. Stop doing that. You could do it yourself. There's a lot of do-it-yourself platforms out there. And I don't know. Good luck. That's a pretty big uptake to do it yourself. There are a lot of platforms. You can LegalZoom and some of these other ones that are out there. But do you know what you're doing? If you want to do it yourself, that's fine. If you're just creating like a simple will, I get that. But when you're starting to get into real estate planning, probably not the best way to do it. You can use a local attorney. you're going to look in the $4,000 to $5,000 range when you do it. The concierge service that we were talking about that My Fit University has partnered with and uses is Simple Estate. And that they have, it is an entire concierge platform, meaning you get to speak with somebody that knows what they're doing. They're going to walk you through the process, and it's a lot cheaper. You know, that they range anywhere from $1,500 to $2,000, and they give a discount for federal employees. It's a great opportunity. I don't care if you do that or not. That's not the, I'm not. It's not a sales pitch. It's utilize something is the point. Do something. If you want more information on that, you know, certainly just put it in the notes, and we'll get you all the information in the concierge service that we use. But once again, understand the options that are there too. You can do nothing. You can do it yourself, use a local attorney, or use a platform that you can get this done, somebody that's trusted, that knows this inside out. And the thing too is, you know, think about this as you kind of think about your options. You have an estate plan. Maybe you have your attorney, right? Estate planning attorney. You got to get your taxes done somewhere. Maybe you do it. Maybe you have a CPA. Maybe some of you have a financial advisor that kind of brushed over the estate planning piece. Maybe you have someone that's doing your insurance, right? We talked about long-term care being such an important piece, life insurance. My question is, when was the last time that your estate planning attorney, your CPA, your financial advisor, and your insurance person all sat in the same room to make sure that your entire estate is working in harmony with each other, right? Maybe your financial advisors growing your money, that's great, but what does that have to do with estate planning? What does that have to do with tax planning? Well, your CPA maybe talking to your financial advisor, that's great, but what does that have to do with yours? I mean, like, you see all these pieces, they all have to work in harmony with each other. They all have to be moving parts that work together so that everybody and every part is on the same page. So if you pass away, your estate is passed as smooth as possible, as tax efficient as possible, and you leave nothing behind. And that's really what estate planning is. So stop putting it off, stop doing nothing. Let's take some action on this. So with that, I want to say thank you very much for attending this. I hope this has been helpful. Hope we kind of kept it easy. I know it's not easy. There's a lot of moving parts, but I wanted you to just kind of rack your knowledge a little bit more as to what estate planning is. Think about estate planning differently. And please, once again, any questions you have, feel free to go ahead, put them all down. There's going to be a survey that pops up shortly. We will get to every single one of you and answer every single one of your questions. Thanks so much for being on. Take care. We'll talk to you soon.